This is my third opportunity to be here at the University Club, and it's one I thoroughly enjoy. Unfortunately, this morning we had some power problems. You will not have PowerPoint presentations, which are here. Last night, about 8 o'clock, with a great sigh of relief, I went out and said to my wife, Ellen, I'm finished. The PowerPoint number 79 has just been put to bed. Dear Manny struggled all morning to try and get my thumb drive to work. It finally dawned on me the reason it won't work is this PowerPoint is all on PD format. Everything else is on the Word format. Nonetheless, I'm going to offer this information to you. I'll tell you right now, I might very well run beyond 12 o'clock. If you're here, fine. If there's just one person here, I'm an attorney, and I was a judge. So it means I had to do some politicking. My wife says I stand in front of the refrigerator and do 5 minutes when it's open before I go. And that's okay. My wife is a very good editorial critic. I got dressed for this morning, and I usually, wifely man says, that's what you decided to wear, eh? And then you know what I mean when I say I change clothes. When a person is confirmed to a seat for the United States Supreme Court, the political umbilical cord which ties the nominee to the political philosophy of his or her nominator is terminated. Every president since George Washington, when making a selection for a judicial position at any level, normally appoints that person, in his day was only men, that shares his political philosophy. But once on the bench, the SCOTUS member, the justice, is released from such encumbrance. A SCOTUS justice is then subservient only to the Constitution of the United States and his or her conscience. Regardless of classification by the media and political pundits as either liberal, progressive, or conservative as a general proposition, once one becomes a federal judge, especially a SCOTUS judge, and SCOTUS stands for Supreme Court of the United States, there's no involuntarily removal in the absence of death or commission of a transgression sufficient for impeachment. The cases we discussed today will, I hope, demonstrate how SCOTUS justices move through all three classifications depending upon the facts of the controversy submitted for ultimate resolution. Further, I hope to successfully demonstrate how landmark decisions are actually the logical result of precedent. There are words that you will need to know as we move through this, and I'm going to give you a few of them. I'm going to throw a lot of information at you today, and I will be more than happy if you want in the future to give you a copy of my text, and you can clarify whatever point you wish. A big word, penumbra, P-E-N-U-M-B-R-A. In U.S. constitutional law, means a group of rights derived by implication from other rights explicitly protected by the Bill of Rights, the first 10 amendments. Abortifacient, A-B-O-R-T-I-F-A-C-I-N-T, means a drug, article, or any other substance designed or intended to produce an abortion. Voluntary or elective abortion is an interruption of the pregnancy before viability of the fetus at the request of the woman, but not for medical reasons. Quickening has been determined to be the point at which a woman can first feel the movement of the fetus, typically around the 4th month of pregnancy. In 1604, the word penumbra was introduced into the language of astronomy to describe the shadows which occur during an eclipse. in terms of law, Penumbra arrived with another judge quite some time later. Now, buried in the landmark, what we call landmark cases, and you will hear them as we go through, is the complex subject of due process of law. As you shall see, due process is a term which appears only twice, and then in only 2 amendments. It does not appear in the core Constitution drafted so many decades, centuries ago. I'll address only 3 areas of law during our discussion: abortion, segregation, and criminal prosecution. And the heavyweight is abortion, because right now, today, in Washington, the United States Supreme Court is hearing argument in one of the major cases about which we will talk, and that's Texas Bill 8, Senate Bill 8. And we'll explore that a little bit today. This discussion is not designed to convince you of abortion per se is either right or wrong. Today's presentation is going to be a clinical analysis of the past and present abortion law. Throughout this presentation, on any one of those topics, I am going to speak to you only of the law and has nothing to do with my personal opinion. In our discussion of abortion, it is important to understand those words I just mentioned: penumbra, abortifacient, voluntary elective abortion, and quickening. The penumbra has been used as a cumbersome metaphor to describe the doctrine of implied powers of the federal government. The implied powers doctrine was first introduced into the lexicon of SCOTUS by Justice Stephen Feld in 1871, a conservative who favored business. He used the doctrine to extrapolate from the 14th Amendment the right to run a business without governmental intrusion. Justice Oliver Wendell Holmes, Jr. came to SCOTUS as a conservative, but he evolved into a staunch advocate of the First Amendment. He embraced the use of the penumbra doctrine in defense of free speech. History has framed Holmes as one of the most outstanding jurists to sit on the United States Supreme Court. Judge Leonard Fleet, who never made it to SCOTUS, served on the federal appellate court. He relied upon the penumbra doctrine to conclude that James Joyce's novel Ulysses was protected by the First Amendment, thereby making it impervious to governmental censorship. However, it was banned in my home city up in North Florida. Judge Hand was a combination of liberal and conservative. He advocated judicial restraint, especially in reference to cases seeking to overrule legislative bodies, but he was the same staunch defender of free speech under the First Amendment of the United States Constitution. Until the late 19th century, voluntary abortion was legal in the United States, provided it was done before quickening. This concept was embraced in the common law of England when America became independent. It was followed by most states, and states began making voluntary abortion illegal in the late 1880s. At the behest of the American Medical Association and various civic and religious organizations, in 1873, Congress passed what's known as the Comstock Law, which made it illegal to distribute contraceptives and abortifacient drugs through the United States mail. By 1900, voluntary abortion was a felony in every state, with some states allowing exceptions for the protection of the woman's life or to terminate pregnancies arising from incest or rape. In 1965, SCOTUS, in a case called Griswold versus Connecticut, struck down the last of the Comstock laws. By a vote of 7-2, the Supreme Court invalidated the law on the ground it violated the right to marital privacy, which appears nowhere in the Constitution. It established the basis for the right to privacy with respect to intimate practices. These 7 justices of the majority disagreed markedly upon where the Constitution or a right to privacy could be found and how it could be justified. Justice Douglas, who wrote the majority opinion, found a general right to privacy derived from the penumbras or zones set forth in the following amendment. Number 1, Amendment 1, which deals with multiple freedoms listed there. Number 3, prohibits forced quartering of soldiers in time of peace. These are all amendments. Number 4, prohibits unreasonable search and seizure without duly issued warrant. Number 5, due process required for deprivation of life, liberty, or property. Self-incrimination is commonly referred to. Number 9, this is a big one that you rarely hear about. The rights not listed in the Constitution are reserved to the people. Further, the court determined the rights of privacy were applicable to the state by virtue of the 14th Amendment due process clause, a phrase which we'll discuss later. Justice Arthur Goldberg concurred by separate opinion in the conclusion reached by Justice Douglas. Now watch how this goes, but for different reasons. Justices John Marshall Harlan II and Byron Wright wrote opinions which concurred in the result, but for reasons different from the other members of the majority. Justices Hugo Black and Potter Stewart both dissented, notwithstanding their dislike of the Connecticut law then under consideration, and neither found a general right of privacy in the Constitution. 1972, a case called Eisenstadt versus Baird extended the protection of Griswold to unmarried persons. The majority opinion written by Justice Brennan was joined by Justice Douglas, Stewart, and Thurgood Marshall. Justices White and Blackmun concurred in the result, but for different reasons. Chief Justice Warren Burger, the sole dissenter, argued, based upon the facts presented, the case was not right for a decision upon the substantive issue of a woman's right to choose voluntary abortion. Now this is something that you're going to see in this reaction of SCOTUS to Texas Senate Bill 8. In Griswold, Justice White was in the majority, but concurred only in the result in Eisenstadt. In Griswold, Justice Stewart dissented, but in Eisenstadt, he affirmed. It is noteworthy that justices who decided Griswold were nominated by 4 different administrations. Franklin Delano Roosevelt, 2. Eisenhower, 4. Kennedy, 2. And Truman, 1. On January 22nd, 1973, a big day in this abortion world. Roe versus Wade, a 7-2 decision. SCOTUS struck down the Texas law banning abortion, effectively legalizing the procedure nationwide. In a majority opinion written by Justice Harry Blackmun, SCOTUS acknowledged the Constitution does not explicitly name a right to privacy, but located the right within the meaning of the 1st, 4th, 5th, 9th, and 14th Amendments, as well as in the penumbras of the Bill of Rights. Justice Rehnquist dissented on the grounds that surgical abortion is not a private proceeding and is thus excluded from the protections found in the 4th Amendment. And I stopped to think about that. The surgical procedure is not private. What are you going to do, out on the sidewalk of the hospital? But in any hospital environment, you have a whole bunch of people. Perhaps that's what he was talking about. But you as a citizen try and walk into an area in a hospital marked for employees only or a surgical suite, when you're not the one who's the patient. Justice White, Roe versus Wade, based his dissent upon the conclusion there is, and I quote, nothing in the Constitution to support the court's judgment, close quote. He concluded his dissent with the statement, quote, as an has authority to do what it does today. But in my view, this judgment is an improvident and extravagant exercise of the power of judicial review that the Constitution extends to this court, close quote. The court divided the pregnancy, this is in Roe versus Wade, into 3 trimesters and declared the choice to end a pregnancy in the first trimester is solely up to the woman. In the second trimester, the government could regulate abortion, although not ban it, in order to protect the mother's health. In the third trimester, the state could prohibit abortion to protect the fetus that could survive on its own outside the womb, except when a woman's health was in danger. Now, there's a difference between being viability outside the womb and viability inside the womb, and we'll cover that. The trimester approach was modified in 1992 in the case of Planned Parenthood versus Casey, which held states could not pass a law which placed legal restrictions imposing an undue burden for the, quote, the purpose or effect of placing a substantial obstacle in the path of a woman seeking a voluntary abortion of a non-viable fetus, close quote. The other point in that case, Planned Parenthood, is the trimester framework was replaced with a standard based upon fetal viability. The court might as well have said on the phrase fetal viability, we are inviting all you lawyers to make a lot of money. The justices who decided Roe versus Wade were nominated by 5 different administrations. Franklin Delano Roosevelt won, Eisenhower 2, Kennedy won, Lyndon Baines Johnson won, and Nixon 4. Today, SCOTUS, as we stand here, will receive oral arguments concerning the controversial Texas Senate Bill 8, which is aimed directly at eliminating abortion in Texas, and it is unique concerning enforcement proceedings. In Whole Woman Health versus Austin Reeves Jackson as judge, that's where the litigation began in federal district court, which is the trial court in the federal system. The Texas Senate Bill 8 prohibits abortion after 6 weeks. Enforcement left entirely to private individuals, and that's an unusual phrase. Individuals who are aware that a woman or any person aiding or abetting a woman, regardless of the extent or lack of extent involvement in the abortion proceeding, can file suit from any of those persons. It doesn't have to be the doctor, the woman is pregnant, but it could be Uber driver who takes them to the facility to conduct the abortion. If the litigation is successful, the person who brought the litigation is entitled to recover not less than $10,000 in damages, regardless of the defendant's ability to pay. If the litigation is not successful, there are no penalties upon the person who brought the action. That person can't be sued for malicious prosecution, can't be sued for frivolous prosecution, can't be forced to repay the defendant's attorney's fees, the court cost, or anything else. The district court in Texas granted the request for the injunction and stay of the implementation of SB 8. Now, I have some great thoughts about what SB stands for. The defendants were state judges, a private citizen in the state of Texas. Now, remember I told you about a justice who said that the case wasn't right, not the right person at the right time. The Fifth Circuit Court of Appeal, which has jurisdiction over Texas, affirmed 5-4. I take that back. The Fifth Circuit reversed. The loser, the plaintiff below, took the case up to the U.S. Supreme Court, And Justice Alito, writing for the majority of 5-4, granted an affirmance of the Fifth Circuit. Now, you're going to hear something called shadow docket, and I'll get to that. Alito was joined by Thomas, Gorsuch, Kavanaugh, and Barrett. The plaintiffs said Justice Alito and those justices were unable to make a strong showing of the likelihood of success when the matter is tried on its merits. Chief Justice Roberts joined the minority of 4, writing for the minorities. He was joined by Breyer and Kagan. He said SCOTUS needs to consider whether a state can avoid responsibility for its laws in the manner set forth in Senate Bill 8. And I'll get to that in just a moment. There was a need to let the merits be litigated in the lower court in the normal course, after which SCOTUS would receive the case after it's been fully briefed and argued, but it should be enjoined because of probability of the loss of rights and irreparable damage to persons in the court below, meaning pregnant women and persons associated with them who might get sued. Justice Breyer, joined by Sotomayor and Kagan, said, I agree with Roberts' analysis. Enforcement during litigation causes irreparable harm to those prevents irreparable harm to those subject to its terms. Pre-enforcement has been previously allowed under such conditions, and the delegation of enforcement powers threatens constitutional rights. Senate Bill 8 from Texas says that no one in government of Texas at any level can bring any enforcement proceedings for Senate Bill 8. Only private citizens, regardless of where they come from. They can come from Argentina, come from Alaska, come from Brazil. It doesn't matter according to that bill, the language of that bill. This is one time I expressed opinion about it. If the state issues an order and then turns around and says, all you private citizens can go ahead and enforce this. Just imagine where that will take you in other laws. And that's the subject matter of the Supreme Court argument today. Under a case called Marbury versus Madison from 1803, the Supreme Court held that where a legal right is invaded by the law, it must provide a legally acceptable alternative remedy by suit or an action as law. And Senate Bill 8 does not so provide. Justice Sotomayor, joined by Breyer and Kagan. The majority of justices have opted in, her quote, to bury their heads in the sand, close quote. Senate Bill 8, she says, is clearly unconstitutional under existing precedents. And the state cannot outsource enforcement in order to avoid a federal judicial scrutiny of an invasion of a federal constitutional right. You cannot hire somebody hanging out at a local bar to enforce the deprivation of a federal protected right. Kagan, with Breyer and Sotomayor joining, said, quote, today's ruling illustrates just how far the court's shadow docket decisions may depart from the usual principles of appellate process. The shadow docket, she said, allowed a patently unconstitutional statute to become law to the detriment of the citizens of Texas. That Texas law became effective September 1 of this year. The shadow docket is the decisions made by an individual justice who's assigned a certain number of states to be in authority. Justice Thomas, for example, is the member of the shadow docket to whom you would appeal on an emergency basis when there's an important constitutional matter at issue and you don't have time to get it before the court. Frequently happens in death penalty cases. On December 1st, 2021, as we mentioned before, the arguments go on a second case, which has Roe versus Wade in its crosshairs. The case is Dobbs versus Jackson Women's Health Organization. This is out of Mississippi. I learned that childhood. I did not spell Mississippi in the beginning until I went into the M-I-P-P-I, crooked letter, I-S-S-I from a kid. Now, Women's Health addresses a 2018 law which prohibits all abortions with few exceptions at 15 weeks of gestational age. The Women's Health and one of its doctors sued the state of Mississippi in federal district court to enjoin enforcement of the Gestational Act. The district court granted the preliminary injunction, which it later made permanent. The district court ruled the state had not provided evidence a fetus would be viable at 15 weeks. Now, this is the state being called upon to defend the law that it enacted in its legislature, contrary to what the state of Texas did. And it said that, let's see, upon appeal to the same Fifth Circuit Court of Appeals in the Senate 8 bill, affirmed the district court's permanent injunction. Not temporary, permanent injunction. The Fifth District Court of Appeal judges who ruled on Dobbs, and what a nice mixture, Greg Coster, nominated by Obama. James C. Ho, nominated by former President Trump. And Senior Judge Carolyn Deneen King, nominated by President Carter. SCOTUS granted Mississippi's petition for writ of certiorari. That's writ of certiorari says, please review. That's different from an appeal, which is an absolute right. When you went from district court to the Circuit Court of Appeal, that is an absolute right. To go beyond the Court of Appeal in the federal system, you must ask for permission to do it. And that's what the petition for certiorari is. Hey, look, the loser said, I've got the royal shaft below. Please, please, look this over and take it out and make me comfortable. The question before SCOTUS today on the Mississippi court has been reduced to, quote, whether all pre-viability prohibitions on elective abortions are unconstitutional, close quote. That will be argued December the 1st. That case, SB 8, has moved with absolute lightning speed to the federal court. 10 days. 10 days is all it took from the time of it was first heard in federal court before it got before the U.S. Supreme Court. I've had cases make their way up to almost the Supreme Court. I was within one justice in one major case. 3 justices said, yeah, we want to look at this case, but it takes 4. But it took me almost 3 years to get there. The ultimate effect of either or both of these 2 cases can be determined only after SCOTUS publishes its decision. The prognostication made informally a few weeks ago by Justice Sotomayor, quote, there will be some very angry people, close quote, after the 21-22 term of court is likely to be accurate. Let's move over to due process, particularly in the field of criminal law. Under the Supremacy Clause that appears in the Constitution, the law of the land is the Constitution, its amendment, and all laws adopted in pursuit thereof. And every judge in every state is bound by that Constitution and those amendments. Now, that's in the core Constitution. But it took the 14th Amendment before the states woke up Although the core Constitution sets forth specific rules in reference to certain specific matters deemed susceptible to criminal prosecution, the phrase due process of law does not appear in the Constitution, nor does the phrase appear in the Declaration of Independence. In fact, the Declaration of Independence has been held not to be part of the law of the United States. Of the 25 amendments to the core Constitution, the due process phrase is mentioned only in Amendment 5, the protection against self-incrimination, and Amendment 14, citizenship, privileges, and immunities that are entitled to due process and equal protection. Meaning you can't take them without due process. Generally, due process is defined as the conduct of legal proceedings according to established rules and principles for the protection and enforcement of private rights, including notice and the right to a fair hearing before a tribunal with the power to decide the case. It's important to know there are several distinct kinds of due process. We'll be concerned with only procedural due process and substantive due process. There are probably 15 different variations on a theme about due process which are presently recognized in law. Procedural due process means the minimum requirements of notice and the hearing guaranteed by the due process clauses of the 5th and 14th Amendment, especially if the deprivation of significant life, liberty, or property interest may occur. Typical examples of procedural due process in our laws are a notice of foreclosure on real estate, for example, or a ticket from a police officer, whether you like it or not, for a traffic violation. But that's a notice of about to take somebody, a power is about to take away from you something protected as life, liberty, or property. Substantive due process means that's in the 5th and 14th Amendment. It requires legislation to be fair and reasonable in content and to further a legitimate governmental objective. Substantive due process is most frequently addressed in the framework of criminal law. Statutes condemning a specific antisocial act must set forth the elements of the crime so clearly a person of average intelligence can ascertain the type of conduct which constitutes a transgression of the statute. When I started practicing law in 1960, Florida had a criminal statute which reads, and this is a direct quote, I'm angry about this statute. Whoever commits the abominable and detestable crime against nature shall be punished by imprisonment in the state prison not exceeding 20 years. The statute remained in effect for 126 years before it was declared unconstitutional for vagueness and ambiguity. And that's an interesting aspect also. Does anyone have any, aside from you lawyers, does anyone have an idea what the crime is? I hope I'm right on yours. The crime is homosexuality. If you're gay, if you're lesbian, if you engage in certain kinds of intercourse not otherwise approved by religious factors, you're looking at up to 20 years in prison. Yes.
Didn't they used to call that moral turpitude?
Sorry? Yes.
Well, they had
Yes.
they said that.
No, but it was moral perpetuity depending upon who was writing the opinion.
Right, but they still have that when it comes to immigrating to this country.
This statute was declared unconstitutional, and the court said, but you can still use lewd and lascivious conduct and disorderly conduct of that nature for prosecution. One of the interesting things about this statute is the Supreme Court had before it a case of questionable facts and rarely Florida legislature met once every 2 years for 30 days. Court said, in essence, but in fancy legal language, legislature, get rid of this statute or we're going to do it for you. And the legislature, as it usually does, ignored the court. And along comes the next case. And the Supreme Court said, I told you what I was going to do, young man. Then I'm doing it. And the statute struck. The problem was that all those people who were locked up for prior convictions, that statute didn't get released.
Oh, wow.
Article 2, Section 4, the United States Constitution provides for impeachment of defined office holders should there be a finding of the commission of certain specific criminal acts, quote, or other high crimes and misdemeanors. A federal misdemeanor is a criminal act for which the maximum penalty is incarceration for not more than 1 year. And if you hear a judge say, I sentence you to a year and a day, the day makes it a felony. If I sentence you to a year and say nothing more, that's a misdemeanor. The big question, however, what is a high crime? And we recently have had reason to work on that, have we not? The highly respected Black's Law Dictionary, that's a staple in the practice of law, defines high crime to mean a crime that is offensive to public morality, though not necessarily a felony. Former President Gerald Ford, during the Bill Clinton proceedings, was allegedly heard say a high crime was whatever the party in power wants it to be. To which I said, what? As we will later observe, different SCOTUS justices have found by implication, that is the penumbra concept, due process to reside in the protection of all these other amendments. With these definitions in mind, let's review the evolution of substantive due process in criminal prosecutions. As was reviewed in one of my previous SCOTUS presentations here at the club, prior to the presidency of FDR, the courts addressed themselves primarily to the resolution of business and real estate conflicts. Excuse me, analogy still walks with me and won't listen to due process arguments at all. Excuse me. Social issues, such as the many alphabetical agencies created by President Roosevelt, and state criminal proceedings were avoided as much as possible by the U.S. Supreme Court. However, deviations in some rigidity to this occur. And these are hot spots and cases I'm confident you know about them, but we're going to talk about them again. Powell versus Alabama, decided in 1932, 2 years before this club was established, was a landmark United States Supreme Court decision in which the court reversed the convictions of 9 young black men for allegedly raping 2 white men on a freight train near Scottsboro, Alabama. This was during the Great Depression, when people rode the rails looking for jobs and whatever other relief they wanted. In a 7-2 decision, SCOTUS held the defendants were denied due process because they were not given a reasonable time and opportunity to secure effective counsel to their defense. The 2 attorneys, local attorneys, appointed to represent these 9 men on a death penalty case, had never been in court before. They knew little to nothing about criminal law, litigation, the strategy, the psychology of selecting a juror. The court, in order to protect an individual's constitutional right to a fair trial in capital case. Let me stop a minute. After those young men case was reversed, as I'm going to mention to you, the person who took over the case was one of the greatest criminal defense attorneys in our American history, whose name I just slipped right out of my head. I meant to write it down. Clarence Dow. The court concluded in order to protect an individual's constitutional right in the reversal of Powell, the state has an obligation under the 14th Amendment to appoint effective counsel for fully educated Florida inmate, the decision of the now famous Gideon versus Wainwright 1963 was announced. Gideon was put to trial in Panama City for burglary of a pool room. An unknown person broke the door, smashed a cigarette machine and a record player, and stole money from a cash register. A single witness testified he had seen Gideon in the pool room around 5:30 that morning, leaving with a wine bottle, Coke, which I hope was Coca-Cola, and change in his pocket. I don't know how he could know there was change in his pocket, but that's what the testimony was. On that evidence alone, police arrested Gideon and charged him with burglary. Now, Gideon was no spring chicken when he was no burglar when it came to court, the criminal field. He was well experienced in it. When he appeared alone in court, he told the judge he was too poor to afford an attorney and asked the judge to appoint one for him. At the time of Gideon's trial, Florida's law allowed for court-appointed counsel only in capital cases. Gideon's request, of course, was denied. The jury found Gideon guilty, and the judge sent him up for 5 years, presumably acting on his own. And we discussed this before the prior session. Gideon filed in vain a petition for writ of habeas corpus in the Florida Supreme Court. Habeas corpus means produce the body, and it's used only, it's in the Constitution of every state and in the United States. Habeas corpus is used only when there is reason to believe there's an illegal detention of the freedom of movement of a particular person who filed the petition. The Supreme Court wasn't going to be bothered with this. They're not going to change the law. The legislature's going to have to do that. So they denied the petition. Gideon hopped on his work stand back at Stark, Rayford, where the state prison is, writes out in longhand on scrap paper, the school board kind of paper, a petition to the United States Supreme Court. To everybody's shock, the United States Supreme Court accepted the matter as a matter of appeal rather than a petition for certiorari. Now, they weren't going to let Gideon come up there and contaminate the halls and argue his case himself, but they appointed a dude by the name of Abe Fortas. Abe Fortas later became a Supreme Court justice after this case. The Supreme Court's unanimous opinion was announced in 1963 by Justice Hugo Black, with separate concurring opinions from Justice Tom Clark and John Marshall Harlan. Pause for a moment. Justice Hugo Black, Alabama, a member of the Ku Klux Klan, who later became one of the most forceful advocates for civil rights on the U.S. Supreme Court. And he said you had to be in the Klan to get elected dog catcher in Alabama. And that's why he was elected. The court held assistance of counsel in a criminal case, regardless of the nature of the punishment, is required by the Sixth Amendment and is binding on the states by the 14th Amendment. And the court reached back to its holder way back in Powell versus Alabama, 1932, to make its decision in 1963. Subsequent criminal decisions, all reliant upon Powell and Gideon, extended the right to counsel in all cases on appeal. The decision in Gideon led to the creation of the public defender system, and there were more than one law student who saw I have a chance to make a living if I'll be a public defender. Along comes a case in 1964 called Messiah versus United States, and another biggie, Miranda versus Arizona, 1966. Further extended the rule to apply during police interrogation. Miranda has two important points in criminal law. The Fifth Amendment requires a law enforcement official to advise the suspect in custody of the right to remain silent and to obtain an attorney at no charge, if need be, and the Sixth Amendment right to assistance of counsel. And I handled my very first death penalty case in 1963. The officers admitted that when the defendant asked for a lawyer, They put him in a room with a telephone dictionary and says, have at it. That was the affording assistance of counsel in Broward County in 1963. The Miranda versus Arizona. In fact, I'm going to tell you something else about that. I went to trial on the case, and that's the case that took all the way up to the all through Florida's appellate system, through the entire federal system, up to, and hopefully I hoped it would include the U.S. Supreme Court. And that was about the time I got admitted to practice before the U.S. Supreme Court. There was a unique issue, I'm not going to go into that now, but I made my presentation to the Fifth Circuit Court of Appeals, and I sat down. The State Attorney General stands up and starts his presentation, and the Chief Judge says, Mr. Blank, do you really think the U.S. Supreme Court is going to uphold this conviction? And with that, I closed my notebook, sat back and took a deep breath, and the reversal came back about 90 days later, goes back to the Circuit Court in Broward County for a retrial, and for reasons not irrelevant, I have to recuse myself from that case in the interest of my client. He negotiated a plea for life in prison. On the day that I retired as a judge, at that time you had to retire if you were 70 years, and I was allowed to stay till 71. On the very day that I'm holding a reception in my office to say goodbye to my colleagues, my mother, God rest her soul, was with us, as was my sister. We're going out for lunch. I get a phone call. It's from that defendant that I represented in that murder case back in '63. He was on lifetime parole. He invited me to come to Boca Raton and have lunch with him. I liked him. I thought he was very kind. I wish you well, but I would really rather be with my mother and sister today. I've not heard from that gentleman since, and as far as I know, he's still doing okay. Now, the retroactivity portion of Miranda versus Arizona, which talks about you must supply effective counsel, resulted in the release from Florida alone of approximately 2,000 prisoners. The court makeup in Gideon versus Wainwright, Eisenhower nominated 4, FDR nominated 2, Kennedy nominated 2, and Truman 1. You can see how the nominators vary in their political beliefs, which is what the justices hold up until the time they take the oath. In Miranda versus Arizona, 5-4 decision. Eisenhower appointed Warren. FDR appointed Douglas. FDR appointed Black. Eisenhower appointed Brennan. And Lyndon Baines Johnson appointed Abe Fortas. In the dissent, Eisenhower appointed Harlan. This is the grandson of the Justice Harlan in the Plessy versus Ferguson case you're going to hear about in a few minutes. Harlan said the majority ruling was not supported by the Constitution. Justice Clark, appointed by Truman, said the majority went too far too fast. Justice White, appointed by Kennedy, said the majority ruling had no basis in the Constitution or in prior precedent. And Justice Stewart, appointed by Eisenhower, just kept his mouth shut and said denied. Now we move into the third field that affects all of us, has affected all of us, and will continue to affect all of us for decades to come, in my belief. And I apologize, it's going to take more than 5 minutes to get through this. The controversial decision in Brown versus Board of Education, 1954, is an excellent example of fluidity of judicial philosophy. And I have to tell you this about, well, I'll get to that one later. In a 7-1 decision, SCOTUS ruled in Plessy versus Ferguson on May 18, 1896. The segregation in general was lawful under the concept of separate but equal. Due to a death in his family, one justice did not participate. The majority opinion was written by Justice Henry Billings Brown, a Northerner. John Marshall Harlan, a Southerner from Kentucky, wrote a powerful dissent, the most famous line of which states an immutable constitutional fact. I quote, "Our Constitution is colorblind and neither knows nor tolerates among classes amongst its citizens," close quote. When Brown versus School Board, now known as School Board Number 1, or Brown 1, first appeared before SCOTUS, Justice Douglas, Black, Barton, and Minton were disposed to overturn Plessy versus Ferguson. Now, if you don't know about Plessy versus Ferguson, I'm going to tell you a little bit. Mr. Ferguson was a mixed-race person living in New Orleans. Louisiana had a state law providing for separate railroad carriages for whites and all others. Mr. Plessy decided he was going to challenge this law. There's a beautiful background about this man. This is no bums in the street. This was a well-educated person. He gets in the white car. The conductor says, "You can't. Man, you can't be here." "I'm going to be here." "Oh, no, you aren't." And along comes the law. And he gets convicted in municipal court of violating this separate carrier rule. He goes up on appeal, and I'm going to discuss that with you in a moment. When Plessy versus Ferguson, Justice Jackson and Reed were inclined to leave the matter of segregation in public schools to Congress. Talk about sending it down a black hole. Chief Justice Vinson died before he made any commitment, and President Eisenhower, believing former California Governor Earl Warren to be conservative, appointed him to the position of Chief Justice. Chief Justice Warren, who believed Plessy should be overturned only by unanimous court, persuaded his fellow justices accordingly. On May 17, 1954, exactly 68 years after the Plessy decision had been announced, it was fully reversed in Brown versus School Board of Topeka, Kansas. That's Brown 1. Brown 1 relied heavily upon the logic of Justice Harlan's dissent in Plessy. The court's decision stated separate but equal facilities are inherently unequal, and therefore violate the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. 5 months after the groundbreaking decision in Brown 1 was announced, Justice Jackson died. And some people say it's bad for your health to be a member of SCOTUS. On November 19, 1954, John Marshall Harlan II, the grandson who wrote the dissent in Plessy versus Ferguson, was nominated by President Eisenhower to take the place of Justice Jackson. Concerned about Harlan's opinions on racial segregation, Senator James Eastland, in his capacity as chairman of the Senate Judiciary Committee, at the behest of several Southern senators and his own personal political beliefs, delayed Harlan's confirmation. In what was an unusual act at the time, Harlan was required to appear before the committee and publicly answer any questions. Harlan's appointment was finally confirmed in January of 1955 by a vote of 71 to 19. 9 of the dissenting senators were from the South. And ever since then, Harlan was the first one. First time a nominee for SCOTUS was required to appear before the Senate Judiciary Committee in public and answer all these questions. But since then, every single nominee for federal judicial position, regardless of level, has to go through public hearings before the Senate Judiciary Committee. Left unanswered in Brown 1 was the question of implementation of integration of segregated public schools. We're just a few minutes away from conclusion. Brown 2 answered the question with another unanimous decision. The several states were required to start making plans on how they were going to integrate their public schools, but the court declined to order immediate integration. The court's alternative to immediacy was the state should integrate, quote, with all deliberate speed, close quote, and the lower federal courts would be the monitors with punitive punitive powers of enforcement. It took almost 25 years for some states to learn the correct definition of the phrase "with all deliberate speed." In light of our discussion today, we must not overlook the fact that both round one and round two were unanimous, thus emphasizing the willingness of conservative and progressive justices to come together on a matter of hugely consequential social justice. That concludes my presentation. I'll be happy to answer any questions.